Melissa Allen, and I'm an estate planning attorney. I would like to introduce myself to you and tell you a little bit about myself and my practice and why estate planning is important. I have focused on estate planning in my practice for the past 13 years. So that's the upfront planning, and I also do the after-death administration of estates, whether it's through a probate estate or a trust administration. I really enjoy this area of law because it's a really positive area of law. Everyone needs to have estate planning done. So my clients come into my office and they feel really good that they've accomplished something that they've been procrastinating on normally, but it's something that they know they need to have done to help their family members, and they leave my office feeling really good that they've accomplished that. I have my main office in DeWitt, Michigan, and I have a satellite office in Corona. And I currently live in Bath, and I have two small children. They are the light of my life. My son is 5 and my daughter is 3, and I have also my husband, Mike. My family is very important to me, and that is part of the reason that I enjoy doing estate planning, because for you to do your estate planning, you're doing it for your surviving family members. Let's start with the differences between wills and trusts. I have a lot of clients who come to my office and they have a piece of paper and it's a will, and they say, here's my will, this avoids probate, correct? But in actuality, all wills go through probate. Now, if you're married, probate would occur on the second of you and your spouse to die, as long as you jointly own everything together. So when I'm talking about the probate process, if you're not married, probate would occur when you've passed away on anything that you don't jointly own with someone else. But if you're married, the probate process would occur when the second of you and your spouse die, again, as long as you're joint in all of your assets. The probate process can be time-consuming. There are a lot of different forms required for probate, and there are certain deadlines on the forms that are required for probate. The probate process takes a minimum of 5 months, but typically a probate estate takes about 1.5 years before it's fully settled. And during this time period, that's when all the different documents are required by the probate court. The cost of probate is another concern of many people, and that really depends on the size of the estate. There's a filing fee as a minimum fee that the court charges, and they also charge what's called an inventory fee, which is based on the size of your estate. And once the estate is probated, once the fees are paid to the court, if an attorney is hired to help with the probate estate, then that adds an additional cost onto probate. And there are some other miscellaneous fees also involved with probate. So probate can become costly, again, depending on the size of the estate. The other thing about probate is everything's public. When a probate estate is opened with the probate court, everything is a public record. So anybody at any time can find out anything about your estate that they want to find out. A lot of people don't like that. A lot of my clients are private and they want to make sure their information stays private. So those are some of the concerns that many people have about having a will done and that goes through probate. A will is better than nothing at all. However, if you want to avoid the probate process, the best thing to do is to set up a living trust. What happens with a living trust, it's a 2-step process. So if you already have a living trust, you have to make sure the second step is followed. The first step is you actually set up the trust documents themselves. In those documents, you get to say who your beneficiaries are. Those are the people or charities or churches that would inherit your estate. You get to say who your successor trustee is, and that's the person who administers your estate. And you can get creative with minor children. You can set up trusts for them that they wouldn't get until they reached a later age. You can make sure college is paid for. Lots of different things can be considered when you're setting up a living trust. That's the first step then. There are a few documents involved with a trust that work together to make sure that the estate is administered smoothly and avoids probate. The second step is very important. That step is called funding your trust. And what that means is any asset that you own that does not have a beneficiary has to be retitled into the name of your trust to avoid probate. So any beneficiary asset, that would go to the beneficiary. Any non-beneficiary asset would have to be retitled into the trust to avoid probate. For example, the deed to your home would have to be retitled or redeeded into the name of your trust. So if it's the Jones Trust and you own that property, it would still be in your name as trustee of the Jones Trust. You still control everything while you're alive as long as it's a revocable living trust. But what happens is by doing this retitling, the assets then become immediately in the control of your successor trustee. So they step right into your shoes on all of your assets that are retitled into the name of your trust. That's the key to avoiding probate. So trusts can be fully administered within a couple of months, depending on, of course, on how quickly your successor trustee gets into action on doing their duties. But it's a smoother process. It's a private process because the court is not involved. Only the beneficiaries of your trust receive copies of all your trust information. So that's why people like a living trust. It avoids the probate process. It avoids the costs of going through probate. And quite simply, it's just easier on your surviving family members to administer your estate. They get it done quicker and easier. And I have so many of my clients that come in and say, this was so easy. What did I miss? My mom or dad has just passed away, or brother or sister. What did I miss? They had a trust. I feel like I've missed something, and they haven't. They have it done correctly, and they have it done a lot easier. So if that's of interest to you, you can explore that more. A lot of institutions have seminars on living trusts. I do a lot of seminars on living trusts. You can simply contact my office and find out when another seminar date is. Another important topic to think about are powers of attorneys. I think everyone should have powers of attorneys, no matter how young or old they are, or no matter what their status is in life. Powers of attorneys, there are two different types of powers of attorneys, and they're effective while you're alive. But if you become disabled or incapacitated, either mentally or physically, and you cannot make decisions for yourself, it's important to have powers of attorneys in place so that someone else has the legal authority to make those decisions for you. The first type of power of attorney is generally called a durable power of attorney for finances, or a financial power of attorney. Those are some of the terms. Those take effect, again, once you've become disabled or incapacitated, and allows an agent to take over on all of your daily affairs for you. So they can do your banking, they can monitor your investments, they can sign your tax returns, they can deal with Social Security and the government. And so those are some of the things they can do on a financial basis for you if you're incapacitated. Now, even spouses need these. A lot of times I have married couples say to me, well, my spouse and I are joint in all of our accounts anyway, I don't need that. But think about it. If you have a 401k or a 453b or some kind of deferred comp or life insurance, only your name is on those accounts. Your spouse is just your beneficiary. So if you become disabled or incapacitated, you won't be able to access those accounts, and neither will your spouse, because they are just a beneficiary. That means that they're not entitled to that money or control of that money until you pass away. But with the power of attorney, your spouse would then be able to access those funds if they needed it for health expenses, or they could direct the monitoring of those funds, the investments of those funds, without having to go to court to be appointed as your conservator. That's what powers of attorneys do. If a spouse had to go to court or another family member, then you're talking about a longer process and a very expensive process. Powers of attorneys are very inexpensive and very easy to obtain. The other type of power of attorney is a healthcare power of attorney, or some people call it a medical power of attorney. That's another very important document. In that document, you appoint a patient advocate to make your medical decisions for you. And that's also the document where you put your preferences on life support. So if you do not want to be on life support, if you're in some kind of irreversible coma or persistent vegetative state, then it's important that you have a properly executed healthcare power of attorney so that you can be taken off of life support in one of those instances. Another thing about healthcare powers of attorneys is they should have a HIPAA waiver in them. And what I mean by that is the privacy law, the HIPAA privacy law came out a few years ago where it really restricts individuals' access over your medical records. But with a healthcare power of attorney that has the HIPAA language in it, then you're saying it's okay, I understand these privacy laws, and I still want my patient advocate to make my medical decisions and be able to have access to my medical records. That's very important. If you have a healthcare power of attorney already that does not contain this HIPAA language, you really need to have that updated and have an amendment done to that in order to prevent any possible problems with your patient advocate using your healthcare power of attorney in the future. So there are two different types of powers of attorneys. One's for finances, one's for healthcare. They're both very important documents. I think everyone should have those. They're easy to get and they're not expensive. So those are things that you should also consider when you're considering getting your estate planning done. Thank you.